Let's hear the arguments in State of Iowa versus Paye. Regenold.
Please the court. Counsel. The front steps of a single-family home are not a public place for the purposes of public intoxication. The district court ruled that Paye's front steps were a public place based on visibility, the right of access by the public, no expectation of privacy, and the decision of this court several years ago, State versus Booth. We know that a public place is defined as any place, building, or conveyance to which the public has or is permitted access. And as we know from a previous decision of this court, a right of public access is the touchstone. Visibility is not part of our code section. So the court's decision that her front steps were visible and not enclosed in it.
But doesn't the public have a right of access to the front door if you were coming to deliver a package? If you were coming to knock on the door? If you were coming to sell a cookie cleaner? I don't think they'll do that anymore. If you were doing that stuff. Political campaign.
There is an implied license, but it's limited in nature, Your Honor. Yes, the public does have the right to approach the front steps briefly to attempt to make contact, but they don't have the right to then set up their vacuum cleaner shop on your front steps. They don't.
Well, let's talk about this. What if they were drinking 1 foot from the property line?
1 foot into the public space?
In the front yard. In the front yard on their own private property, but didn't go across the sidewalk. With the right of way. Well, let's assume the sidewalk and the things on the other side of the sidewalk are public right of way.
Okay.
Is that public intoxication if you keep your toes behind the sidewalk?
No, it's still not a public place, Your Honor. The public still only has a limited right of intrusion because we have a property right which is broader than our expectation of privacy once we get to the constitutional portion of this. I have the right as a homeowner to deny access or bar access. So while people may come up to deliver packages or approach me about political campaigns, I have the right to say, not interested, get off my front steps.
Right, but the person is permitted access and then you can send them away. Wouldn't that be a fair characterization of what you just expressed?
They have a brief moment of access, Your Honor. It's not the same as public access in the definition.
But it says it's a place where the public has or is permitted access. There wasn't a gate here, right? This
Correct.
isn't a locked. Someone could come up to the front door, as we've established, for any reason at all, and then it could be sent back. Why isn't that being permitted?
Because it's my property and I have the right to deny that access. So this implied license or this custom that we have in our society allows that limited approach, but that does not render the front steps a public place.
Wouldn't you have to put like a no solicitor sign out there in order to deny these people limited access for it not to be public place?
No, Your Honor, as was discussed in Booth, no tenant had the right to deny access to the entire apartment house because it was a common area. But they did have the right to deny access at the threshold of their apartment, just as we have the right to deny access at our property.
Is the statute ambiguous?
We have not challenged it as ambiguous, Your Honor.
Well, wouldn't most people be surprised that they could be arrested for drinking on their own front steps?
Yes, I believe they would.
Isn't there a difference between the right of access, let's say a public park, anybody can go and stay there. Isn't that different from somebody's private home? You can't just walk up and stand there and stay in their yard.
I agree, Your Honor. Because no one person has the right to bar access to a public park. But the homeowners, in this case my client, had the right to bar access to her home.
Okay. She had the right to bar access to the house, but my understanding of the facts of the case is she summons the police because of an alleged domestic assault that occurred. She summons the police, and she's out on the porch when the police arrive. Isn't that correct or not? I think it's maybe not quite clear, but in any event, at least the record then shows that she meets the police officer on the steps at her invitation. And how can we say that she may have had the right to deny access, but under the facts of this case, she granted access? How do you get around that?
The fact that she invited someone doesn't change, it does not transform the nature of her front steps or her property. The fact that I invite someone to my home or she invited the police to her home does not transform that to a public place. Now, some cases in other states have talked about if you have, say, an open house where you invite anyone who wants to come, maybe then you have some question about a public place. But if I invite guests over, call the police, allow the salesman to come in with his vacuum cleaner, that does not transform my home or my front steps or my property to a public place.
I think if I understand your argument, I think you're advancing the position that is expressed by Justice Carter in his dissent in Booth. And there he says, I submit that public access refers to access by the public at large without invitation. And if I understand Justice Carter's dissent, he sets up this analysis. He says, those who have access by invitation, either express or implied, are there not as members of the general public. And so I think Justice Carter would answer some of the questions that have been posed to you in this way. He would say the dinner guest obviously is coming with an express invitation. He or she is not a member of the general public for purposes of the statute. The vacuum salesman that Justice Wiggins talks about comes by implied invitation. We sort of give this implied invitation for some folks, Girl Scout cookie sales people and the like, to come up to our door. But by extending that implied invitation, we're not saying anybody in the public is welcome to come up to my front step, right? Is that really what your argument is?
Yes, Your Honor.
Okay.
Well, the way big majority moves, which goes on at some length about the breadth of the statute and the statutory purpose, even going so far as to say that the purpose of the Alcoholic Beverage Control Act, is to protect the welfare, health, peace, moral safety of people's lives. I'm not 100% sure what you're saying that. But which shall liberally be construed. If we're going to give this statute liberal construction, doesn't that make it stale and limited?
No, Your Honor, because one of the rules of statutory interpretation is that you don't create an absurd result. And I think that saying that the front steps of a single-family home are a public place would be an absurd result.
Why? I mean, here's a drunkard in front steps of the house, annoying neighbors, passers-by, disturbing the peace. You don't want your children around someone who's drunk on the front steps, et cetera, et cetera.
That person, which obviously was not my client because there's no evidence that she was a nuisance in any way, but that person may be subject to other statutes or municipal ordinances, but would not be subject to.
No, but this statute's so clean because if you're intoxicated, I mean, you do a blood test, it's objective evidence. This business is some of our other statutes with their elastic terms.
Disorderly conduct, Your Honor. Loud and raucous noise within the vicinity of a private residence or public building.
Well, in case it wasn't loud and raucous, but it's clearly drunk and looking in a leering fashion at the children walking by. I mean, drunkards behave in ways we don't care for. People who are intoxicated behave in ways that are socially troublesome. And the legislature uses admittedly very amorphous language, and I'm truly not sure what it means, public safety, moral, and so forth. But it does talk about liberal construction, which suggests that, intoxicated persons, the legislature is really interested in keeping intoxicated persons out of the public view.
Well, they can keep them out of the public view, but that would not, in my estimation, include the front steps of a single-family home. That is not a public place.
Is it your construction of public place, which you're saying is, it has to be a place where the owner of the property doesn't have the ability to deny access. Isn't that your position? Here, the owner of the property has the ability to deny access, whether they did or didn't. And therefore, because they have that ability, that makes it not a public place. Isn't that your position?
That is one facet, but yes.
Well, but isn't that totally inconsistent with Booth? I mean, in Booth, we said even the interior hallways of an apartment complex are a public place.
Yes, Your Honor, but in that case, the court also found that the other tenants were members of the public. And so they had the right to be free from the obnoxiousness of someone drunk. Whereas in this case, what we have is people who live in the home. And there was no...
So what if this had been a duplex? Front porch, what result in that?
I think that would be different, Your Honor. Well, it would depend on the duplex. Is this a duplex that has separate individual entrances, or is it one that has, some of them will have one entrance?
Why don't you give me answers to both hypotheticals?
I think if they each have their own entrances, some duplex will have one entrance over here for resident A, one entrance over here for resident B, I think under Booth, that would not be a public place because they have the right to bar access. But under Booth, if they have a common entrance and then there's separate entrances, if they're in that common area, I think under Booth that would be a public place.
What if they had a tenant in the basement?
I don't know if they have a separate entrance.
But I mean, you see what I'm driving at. I agree, it's a difficult statute to construe, but we have to do the best we can.
Well, it seems to me that what you're arguing for is a bright line rule that the front porch of every private residence, regardless of the factual background or posture that we have, is, you're asking us to say it's not a public place, it's a private place. And again, I harken back to the idea that she's outside there, and we've talked in other cases about the bubble of privacy that you lose when you go over the threshold of a house, which is what we have in this case. On the front step, somebody that's there in response to your specific invitation. We're not talking about implied invitation here. We're talking about an explicit invitation to the police to come to my house and come talk with me on my front porch. And I think the absurd result is to have a bright line rule that simply says, oh, the front porch of a house under all circumstances is private. You're not arguing that, are you?
I am, honestly, Your Honor. I think when you're getting into questions about expectation of privacy, you're getting into a constitutional analysis, which is part of what the district court found. And I think it confused those because the property interest and the Fourth Amendment expectation of privacy can at times align. There's some talk of that in Florida versus Jardines. But more often, the property interest is broader, as is talked about in Oliver and Santana, than that expectation of privacy. I am not saying my client, we have the picture in here, it's a very simple front steps with railing, it's not enclosed, there's nothing fancy about it. I am not saying she had an expectation of privacy on those front steps. I'm saying it is not a public place.
But if we rule in your favor and use this bright line approach, every single family home is private. And just thinking of Iowa City Hawkeye games, Melrose Avenue, a private home with 50 students drinking out of a
And
can.
making a loud and raucous noise, Your Honor, disorderly conduct.
If they're not disorderly, they're simply drunk. The police can't do anything about it.
If they're in a private space and they're not violating any municipal ordinance, and we know police are pretty creative, they can usually find something that my clients are guilty of, I find. But if they're conducting themselves quietly and just sipping a beer and not disturbing the peace, I think that's okay.
Yeah, and that's where I kind of struggle with the disconnect here, because that's fine. I'm not arguing that if I'm sitting on my front porch at my house and I'm drinking a beer without anything else, that I don't probably expect that a police officer is going to come up on my deck and start asking me questions and then going in the house and asking who the alleged perpetrator of the domestic abuse was and carrying on this whole investigation. But if in fact I call the police and I'm out on my front porch because I think there's a problem within my house, don't you think that that turns it more into a public spot?
No, Your Honor, I believe it was still her private property.
Counsel, if I understand your argument, again, consistent with Justice Carter's view, that police officer would be analogous to the express invitation to a dinner guest, who's not, it's not a situation where you throw your house open to the public for access, right?
Right. Thank you. We would ask the court to reverse and remand to the district court.
Thank you, counsel. Mr. Parrott, on behalf of the state of Iowa.
When the legislature arranged a crime to be intoxicated in a public place, the legislature expressly defined the phrase public place as any place, building, or conveyance to which the public has or is permitted access. And so, as this court recognized in Lake, the touchstone of the question is this right of access. And in this case, the public did enjoy access to the defendant's front stairs, and so that made them a
Well,
public place.
let's say I'm having my daughter's wedding on the front lawn of my house, and I don't invite anybody except the guests. If there's someone drunk at the wedding, can the police come out and take them away?
I think in that case, Your Honor, you have perhaps revoked this implied right of access. After all, it is what the case is called sort of a traditional invitation. And I do think it can be revoked, either through...
Well, is it or isn't it? I mean, can the police come out and arrest some drunk guest at my party?
I think no, because you have revoked it. So I think the reasonable person in that situation would not believe that they at that time have, they're free to come up to your front door and knock, and so you vacuum cleaner.
Do you think Booth requires us to decide the case in your favor?
I don't think so. I think it expressly left the question open. I do think the state's position finds a lot of support in Booth, especially because Booth says that the entire public doesn't have to have access to a given place for that place to be a public place.
This language in Booth sort of bothers me. And here's a quote, let me just read it to you. Although each has signed a lease in the same building, each remains entitled to be free from nuisance and annoyance and to be protected from the actions of fellow tenants. This key factor mandates a construction of the statute that protects the interests of an offender's fellow tenants and others in the common areas of the apartment so as to avoid an invasion of legislative intent and purpose. We don't have this key factor here. And I think we're going to have to extend it to get to where you want to go, because as I read Booth, the whole basis of the decision was that everybody had a right to the common areas, and that's pretty established in common law, that common areas are open to the public. We all consider common areas public access areas. And there is no common area here. So how do we extend Booth if that's the key factor? Because it was very narrowly written in that case, I think.
And I think we have an analogous factor here. Just as the co-residents of the multifamily dwelling in Booth were entitled to the protection of these public intoxication law, so is the public that enjoys this implied license to approach the front door of a single-family dwelling.
So if you have a no trespassing sign, no solicitation sign, something like that, you could avoid the statute?
Correct. If you
If the
revoke,
legislature intended that, then the individual homeowner has the capability of avoiding the statute's general applicability by just taking out a no trespassing sign?
frankly, no and yes. I guess no. They didn't probably, the 150 legislators, probably all
How
did.
about objectively? Let's not worry about the
So objectively, yes, via the language that they use. And that's really one of two fundamental rules of statutory construction I'd like to mention. The first being that the express language of the statute should prevail. And in this case, again, the legislature did expressly define public place.
If you see someone wanting to live in a town, and you're driving down the streets of this town, and of Decorah here, and every house says no trespassing, no trespassing, no trespassing, what a great place to live.
No solicitation.
I mean, is that what the legislature really wanted to do by this law?
The legislature wanted to do what they objected
Would
to.
anybody want to live here?
I don't think that's the legal test in this case, Your Honor. The test is what language did the legislature use? And they used this word access. And they didn't define it. So I think another fundamental rule of statutory construction is that we read that word in its ordinary sense. And so we often get this ordinary sense from a dictionary. So
How would you answer Justice Waterman's question? Is it ambiguous or not?
No.
Or is it plain?
I think it's clear, and I think we're entitled to, again, look to the dictionary definition of the word access, which Webster's defines as a means of approaching or a right to enter or use, and Black's Law Dictionary defines as an opportunity or ability to enter, approach, or communicate with. And I think that this short path from the public sidewalk to the defendant's front steps provided that ability to communicate, that opportunity. And I think historically, the implied right of access gives the public that right.
So in answering that question, you didn't focus on another word that might be ambiguous, and that's the word the public, the words of the public. I mean, that could have several meanings, couldn't it? It could mean anybody. It could mean anybody except those who have an express or implied invitation. It could mean any person. Isn't that ambiguous?
I think Booth answered that question for us, Your Honor. It says it doesn't have to be every member of the public. As long as certain members of the public have access to that place, then they are entitled to the protection of the public intoxication laws. They're entitled, not to be leered at by the drunkard on the front steps, as Justice Appel talked about.
Well, Mr. Parrott, the word access under the statute is used as a noun, and you've given us a definition of that noun. Are you suggesting that this is just a factual test that we apply and there isn't any need to analyze whether someone has a legal right to access, that we simply look to see if factually a person in the public would be able to approach this place?
I think, at a certain level of generality, it's probably a mixed question. There is the legal right, the implied right, but then when we get down to it, I think there are fact questions that a jury will decide, such as whether the resident of this single-family house revoked the implied license to approach, whether the defendant in the particular case was inside or outside the scope of that implied license.
Well, even if there was a sign that said no trespassing, would someone in the public still be able to approach that home? There's nothing preventing them?
I think a sign posted where the public can see it would be enough. And I think, interestingly, or importantly, this is a fact question that the jury is particularly well suited to answer. And as Justice Paye put it, this is not a question that takes a legal technician to answer, or as Justice Holmes somewhat more laconically said it, a license can be implied from the habits of the country. And the jury is the body that we look to determine what the habits of the country are. And importantly,
But wouldn't jurors understand the difference between a truly public place like a park, where you can go and stay, and a private home where you can walk up to the front steps, but you can't just hang out there. You ring the doorbell, you whatever your implied right of access is, you visit, and then you leave. Isn't it limited?
yeah, I think the jury would decide that. And I sort of envision it almost instruct the jury about the implied license and say, you know, as long as the resident hasn't revoked, then you may find.
Doesn't this, your definition run afoul of some privacy rights under the Iowa Constitution, the federal Constitution, curtilage law, dealing, about police not being able to go into those areas because they're part of the home? And aren't you pushing the envelope here? I mean, as multiple families different, you're doing on a single family dwelling.
I don't believe I am at all, Your Honor. 9 members of the United States Supreme Court in a Fourth Amendment case, Florida versus Jardines, recognized this implied right of access. They essentially said certain areas of the curtilage are really only semi-private. Justice Scalia and the majority said a dog sniff probably exceeds the scope of that implied license. So so it is a search in the Fourth Amendment case.
In State versus Lewis, though, we said you can't go in the curtilage. In one of our Supreme Court cases.
Well, in that situation, the police couldn't go in because they didn't have reasonable suspicion to believe that a crime was occurring, or they didn't have probable cause to go up. And I think that was also a back porch situation, not a front door situation. And the implied license has been defined in the cases as the ability to approach the most obvious and prominent entrance by the most direct path, to knock on the door, to linger there, and then if you're not invited in, then you must leave. And so I do think we can square the Fourth Amendment case law perfectly with.
So if this was on the back porch, there would be the prosecution's case would have a problem.
Absolutely, Your Honor.
What do you make of this language, this part of the statute that says public place means a place to which the public has or is permitted access? We seem to be kind of reading those two together. Is it has access and is permitted access mean the same thing? Is that your view, or does the word has access and?
I think, under our canons of statutory construction, it has to add something because we don't read
What
words.
does it add?
I think perhaps it does two things. One, it shows us that the legislature used a broad construction. They wanted to include multiple types of behavior, and perhaps it adds, has is sort of in fact, and then is permitted is maybe in law or by, express or implied has access.
Or perhaps the places, buildings, and conveyances that the public has access to are public buildings, public conveyances. The public owns them, so they have access to those places and those buildings and those conveyances, right?
I think that.
And the other phrase, or permitted access, perhaps relates to other places. Private property, where businesses hold their premises open to the public and have business invitees coming on board to do business. But what's troubling me is here we have a private property, a private residential single-family dwelling. And that is so different, isn't it, in our custom and in our usage from the public places, the public properties, and the business properties that take all comers onto their properties. And so doesn't this have to be a much more limited kind of concept when we're talking about single-family dwelling?
I acknowledge that the two are very different, Your Honor, but again, I return to the language of the statute, and the legislature expressly defined the phrase public place, and it did so by reference to access. It didn't, do so by reference to who owns the property, who holds title of a public entity or a private citizen. It did so by this word access, and I think we can assume that it did so to protect the entire public against the ills of intoxication that they were seeking to address this argument.
Is the state relying on the fact that the defendant called the police and invited her in?
I don't think it's necessary to our case because we rely mostly on the implied right of access. And it doesn't really add much because whether the access was expressed or implied, there was still access. But yeah, I don't think it hurts our case either.
So if the state wins this case, somebody drinking quietly, but to the point that they become drunk on their front steps, a policeman could walk up and arrest them?
Yes, Your Honor. There's no, based on the plain language of the statute, there's no added element to the crime. I think, we're one of 6 states where just being intoxicated in public is a crime, and then there's perhaps almost 20 more where you need intoxication plus something else like boisterousness or a disorderly conduct type of scenario.
But if the Delta House wanted to have a crowd of guests get drunk on their front lawn, all they have to do is put a no trespassing sign, and they're good to go.
As long as they can revoke the implied right of access, then they've made that property no longer a public place under the legal definition under the statute. I see my time is up, so the state would respectfully request the court to affirm the judgment of the district court. Thank you.
Thank you as well, Mr. Parrott. Rebuttal argument?
I think one of the matters that we haven't talked about is that one of the purposes of the statute is to prevent nuisance. And in this case, there was no indication that my client was a nuisance to anyone. There was no one else who called or complained about her behavior or conduct.
Statutory words don't say you have to have nuisance. The point isn't the point well taken. If you look at all these statutes across country, every state seems to have a public intoxication statute. Our statute falls in kind of minority of 6, and I don't know how many fall in that category. I take Counsel word. A lot of them have additional elements tacked on. Ours simply doesn't.
But in Booth, we adopted that legislative intent that the purpose of it is to prevent nuisance.
Right, so we have a broad prophylactic rule that just says, look, we're not going to make case-by-case judgment for whether you're too boisterous or whether you're not boisterous enough, or you're too boisterous. If you're drunk, you're going to get charged. You can't take that kind of, admittedly, kind of broad approach to criminal law.
I don't think so, Your Honor. And I think if the legislature were concerned after the Booth decision and the footnote that it dropped about distinguishing the front steps of a single-family home, they could have changed the statute, but they chose not to. I also think that counsel's argument that right of access is revoked if one of us has a party on our front lawn, I don't think that's particularly clear for the police. One of our concerns, or yours and mine, is that the police have some clarity in making their decisions. So now if someone is drinking on their front steps but they have a no trespassing sign, the police can't arrest, but if the neighbor next door is drinking quietly on their steps and they don't, the police can arrest them. I don't think there's any clarity or guidance there for the police in their actions.
What do you make of the language in Booth that the statute is broadly interpreted?
It was broadly interpreted in Booth, but that was a different factual scenario because we had an apartment house where we did have other people coming in who were affected by the conduct. But I don't think that means that we have to broadly interpret it in this case.
Let me ask you a question about another sentence in 123.46.2. It also says, a person shall not use or consume alcoholic liquor in any public place except premises covered by a liquor control list. We would agree, don't we, that public place has to be consistent between one sentence of the statute and another.
Yes.
So, if public place includes the front porch, that means you can't drink beer on your own front porch unless you've got
A liquor
a
license.
right? So there goes the party we were.
There goes my kid's wedding.
there is some disconnect there, Your Honor, yes.
Yeah, I mean, it seems to me this is maybe a point in your favor, because if the definition extends that far, it's not merely a prohibition on being intoxicated, it's a prohibition on consuming alcoholic beverages.
I would agree, Your Honor. If there are no further questions, then I would cede the remainder of my time and ask the court to dismiss the charge against my client. Thank you.
Thank you as well, counsel. Case of State of Iowa versus Patients Paye has now been submitted to the court. And before I